Hello, and welcome to the podcast, Creditors Corner Legal Talk, presented by Smith Debnam, Nairn Drake, St. Sing & Myers, LLP. My name is Lauren Reeves. I'm a partner in the firm's business law section. Before we begin, I do want to note that the information provided in this podcast does not and is not intended to constitute legal advice. Instead, all information and content is intended for general information purposes only. Listeners should contact their attorney to obtain advice with respect to any particular legal matter. With that out of the way, we will turn our attention to this week's topic, which is estate planning, generally. I guess we could call it Estate Planning 101. We have two guests today, and they're here to discuss the important topic. And it's Gene Cianelli, who's been on the podcast before, and Andrew Bullard. Welcome, guys.
Thank you.
Thank you, Lauren.
Well, let's start. Are you ready to talk about estate planning?
Absolutely.
All right. So basic intro 101 question. What is estate planning? Why is it important?
Estate planning is important for a number of reasons, but I want to kind of address a perception about estate planning that I think is out there. And I think a lot of people think that, well, estate planning is just about who gets your things, who gets your stuff after you pass away. And as we'll discuss today, it's really about a lot more than that. It's about planning for your death, both in terms of who gets your property, but also when do they get it? Where does it come from? And how smooth is that transition of ownership to them? The other key thing with estate planning is that it also has a lot to do with what decisions are made while you're living. So if, for instance, you fall under some incapacity at some point, whether due to an illness, for instance, a properly executed estate plan can address what happens in those scenarios and say who can make decisions on your behalf and so forth. So again, it's about a lot more than just what happens to your property after you pass away.
So what if you don't have a great deal of money? Do you still need an estate plan?
This is Andrew Bullard. Yes, you absolutely do. Whether you think you have an enormous amount of money or you have a car and like one bank account, absolutely you need an estate plan. You'd actually be surprised at what you pass away with. And if you pass away even with only a vehicle, there's still a title that goes along with it. If you want that specific item to go to somebody, you're going to need a will or you're going to need some alternate way of getting it to them. The response I hear most often from clients is, well, I've got joint assets, I have beneficiary designations, I've taken care of everything, so why would I need a will or power of attorney on top of that? Well, maybe you don't. Maybe all those assets will get to where they're supposed to go, but I can guarantee you're not going to get everything. Personal property items don't have titles with them. So if you're looking to create a dispute, don't do an estate plan. If you are looking to create a dispute, then absolutely just tell somebody how you want your property distributed and wait for the fight to erupt.
Yeah, and I think another thing that sneaks up on people is a lot of times people will have a larger estate really than they perceive. And by this, so they may have life insurance, for instance, or real estate or, other investments that have built up a lot of equity that they may not have, paid a lot for and they don't perceive as being that valuable as a result, but actually are much more valuable than they think. Another asset that people have that I would put in the category of kind of sneaking up on them in terms of values is retirement accounts. A lot of times people will have huge amounts of money in their 401k or other kind of retirement accounts that they just don't think of as being part of their estates. So I think Andrew's right, beyond just not wanting to set up the fight, as it were, but a lot of times people have more assets than they think.
So it sounds like estate planning is for everyone, living and then it benefits everybody after you're dead because it doesn't make it as difficult on your family members or next of kin who are dealing with that. Particularly because estate planning can help you during your life and then can help your loved ones.
Correct. It's more about the people who are, it's more about your other family members than yourself.
Okay, so let's go into what happens if I don't have an estate plan when I die. There's some rumor floating around that the government gets all your money.
Well, that rumor is untrue. The government doesn't come in and take all your property if you die without a will or without an estate plan in place. What the government does do, what North Carolina and every other state's law does do, is provide for what's called intestate succession, meaning it dictates what happens to your property if you die without a will. And in North Carolina and every other state, there's statutes on the books that say if you die without a will and you leave, say, a wife or a surviving spouse and children, then the property is divided up primarily or entirely among them in certain percentages. And states vary a little bit as to what those percentages are and things like that. But it's generally the case in North Carolina and really every other state that they would get the lion's share, if not all, of your estate if you die without a will.
So, are there risks to not having a will?
There are definitely risks to not having a will, especially what Gene just described. If you have a spouse and children, you can come into a situation where you can become an owner, especially on real property with a minor child. And trying to sell a piece of property like that can require going to court for administration to get that freed up. I would say if you don't have a will or you don't think you need one, go down to the courthouse and see how many guardianships there are for minors and who've had to have situations like that resolved. The easiest way to take care of something, especially for spouses, is just leave everything to the surviving spouse and then take care of children after that if you have children.
So, all right, let's talk about drafting your own will, or do you need a professional to do that?
I love people who draft their own wills because I get to mostly probate something that is complete garbage. But you can draft your own will. Absolutely. There's a different way. I mean, there's different types of wills. There's holographic wills. There's your traditional will, which is two witnesses. If you want to make it self-proving, it's two witnesses and a notary notarizing all of the signatures on the document. If you're going to try and do your own, absolutely can be done. Good luck in some ways, because it's probably not going to work out the way that you think, mostly for the fact that you're probably going to get distributions wrong, or you're going to get the executor provisions wrong, or you're going to try and create something very simple for your family that's going to create a conflict in many ways. But if you want to try and do your own surgery at home and don't want a doctor, then go for it with an attorney as well, and don't use us to do a will.
Very clearly stated.
The other thing I would say about that is, if you think it's going to work with just telling family members how you want something divided, that is probably going to also result in a conflict or litigation. We even in meetings all the time, we get people who will say, well, I'll just leave it all to my son, or I'll leave it all to my daughter, and they'll do, quote unquote, the right thing. I can tell you probably 8 out of 10 times the right thing doesn't happen. So if you really think that your children or somewhat distant loved one is going to get along and they're going to be kosher about everything, it's probably not going to happen most of the time. And if it doesn't, then you've just made it that most likely you're going to make lawyers very rich.
Well, and the right thing isn't really definable, or it's
pretty arbitrary.
Right.
Yeah.
Right, and I agree with Andrew in that it's in my experience, it's the exception rather than the rule that the person who, the person who's died is so convinced will do the right thing, actually does it. And one more thing, there's different states are kind of all over the map as to whether they will formally recognize an oral will. There are some states that will only do so in very limited circumstances, some states not at all. Some states it has to be a real kind of deathbed scenario where the decedent is literally on his or her deathbed and they make a declaration about who they want to get certain property. It is not recommended at all. And I also don't recommend you drafting your own will either, even writing it down.
All right. So we know it's really important to have a will. We understand how it affects loved ones after death. So how do I create an estate plan? What do I do?
Yeah, I think.
And when?
Well, as soon as possible. A lot of times clients will, it can be some life event that will trigger their thoughts of doing an estate plan, having a child, getting married, getting divorced. And those are all great times to start. But of course, as we discussed before, a lot of times people don't think they need an estate plan when they really do, because they just have more property than they thought. But obviously, start as soon as possible. Other thing to keep in mind is don't just do an estate plan and kind of sit on it. Review it periodically. Contact your attorney who drafted your estate plan for you periodically, and just check in with any life updates there were. If there were children or grandchildren who came along after you did your estate plan, it's important that to kind of see it as an organic plan that evolves as your life changes, rather than just something you do once and kind of forget about.
Also, as a PSA to that, if you think when you're in the hospital that's the best time to start your estate plan, it's not. That's probably not going to occur. It takes a little bit of time to draft these type of documents. So don't be sitting on your deathbed and think, I'm going to call the attorney right now and get something done to make sure it's taken care of.
So for the type A about us who like to schedule things, is there periodic things? Is it all in with life changes? Is it every few years? What do you really recommend?
I really recommend the every few years route. Even if nothing has really changed, again, I think, once you talk and interact with your estate planning attorney, more has really changed than you think. Even if another child hasn't come along. I mean, you may have switched jobs, may have started a business, may have acquired or sold different property that's critical to your estate plan. You might decide, or might have decided, hey, I want to benefit charity with my estate planning. I mean, these are things that can happen, and you kind of just don't think about them or necessarily perceive them as major life changes, but they nevertheless will have a significant impact on your estate plan.
Yeah, and as a follow-up to that, I think what we hear most often from clients, especially when they're looking at them every 20 years, is, I didn't know that document did X, Y, or Z. Right. And it comes as a surprise to them that 20 years ago they would have set something up that way. Well, if you look at it every 2, 3, 5 years instead of cracking it open every 20, there's a better chance that you can call your estate planning attorney to see, what is the document doing? Is it still functioning the way I want it to? If it isn't, let's amend it.
Yes.
So estate planning is more than just a will. What do the other estate planning documents do? What are they?
So the crux of what you're always going to be building around is a will. You're always going to be doing death planning. You're going to want an executor in there. If you're going to have to put something like a testamentary trust for children, and you're going to have to assign guardians, we're going to want those type of provisions in a will. What I would call your basic estate planning package is a will, a durable power of attorney for finances, a healthcare power of attorney, and an advance directive. What you're trying to do is take care of every situation where you can't make a decision for yourself. So the healthcare power of attorney and the durable power of attorney will take care of you if you're ever incapacitated for your estate and for the estate of you as a person. Your will is going to take care of you when you pass away. So anytime you can't make a decision, you want somebody there to be able to take responsibility to do that.
Yeah, and I would just agree wholeheartedly with what Andrew said. One thing I would mention is that a lot of times the advance directive that he mentioned is often referred to as a living will, and the crux of what it is it addresses end of life situations. How do you want your last illness to proceed in terms of, do you want to just be made comfortable? What about life support and artificial nutrition and hydration and things like that? Do you want that or not? It's basically you saying to your power of attorney and to your healthcare providers, I do or do not want these measures taken to prolong my life if it's clear that I have a terminal illness. And so again, that's often called a living will. So,
and again,
yeah.
The whole point of that is to take the burden off to close people around you and
Correct.
family members who may have to make those difficult decisions.
Correct. It provides you some certainty, and then it also gives them some comfort that they're not put in the situations where they have to act or not act in some way that would be inconsistent with what you want.
And if you don't set it up, the alternative is you're going to court to get a guardianship for somebody. Yeah. It's expensive, it's time consuming, and you're not going to like that process. It's much easier to set up the documents, do the planning beforehand, and have people in position if you ever do have some event that occurs where you're going to need somebody to take responsibility for certain things in your life.
So it sounds like these documents are important before death and after death, and they affect the people you care about most, both before and after death.
Yes.
That's a great way to describe it, Lauren.
Thanks. It's so fantastic talking to you. Anyway, so you mentioned trust, and you mentioned a testamentary trust. There's different types of trusts. Mm-hmm. What are they? How do they work? Does everybody need one? What is this trust fund baby thing we all hear about? Is that the unicorn?
They're not unicorns, but they are, I think, a lot more rare than we think. Basically, the structure of any trust is you as the person creating the trust are giving property to another person or entity called the trustee, and it's the trustee's responsibility to hold that property for the benefit of a beneficiary. So I set up a trust to benefit my children. I give a certain amount of property to a trustee. Trustee holds that property with an eye towards preserving it and growing it for the benefit of my children. When it kind of all boils down to that with a trust. Now, that being said, there are a lot of different purposes for which you can set up a trust. You can set up a trust to benefit a beneficiary who may be under some incapacity, either because they're, say, a small child and can't manage the property themselves. You set up a trust to benefit them with an eye towards the trust ending at some point and the child getting the property outright. You may set up a trust for a beneficiary who's under another kind of disability, whether it's an illness or something like that, again, just to preserve the property for their use and benefit. Other kinds of trusts relate to specific properties. So, for instance, a lot of times trusts are set up to receive life insurance proceeds, which has a very significant tax benefit from an estate tax standpoint, but they're very specialized trusts for that purpose. But again, it's the same structure. Property goes to a trustee and is held for the benefit of a beneficiary, with the management of the property being put in the trustee's hands.
So I heard if I have a revocable trust, which is a different kind of trust than what you were just talking about, I wouldn't have to pay estate tax. Is that true? And can you talk about revocable trusts versus the other types?
Yeah. So the biggest difference between like a testamentary trust and a revocable trust. Testamentary trust is one that's included in your will, and it's just set up in that document. A revocable trust is a standalone trust document that will allow you to put assets in there while you're living and do administration in there while you're living as well. You can also amend and revoke it as you see fit. as it relates to estate tax, so the estate tax right now is 11.58 million in 2020. And if you're going to hit it, a Rev Trust won't help you. There are different types of trusts that we can take advantage of to help minimize the tax burden. But a revocable trust is just you in a trust form is what it is. And when it comes to estate tax, you're not going to be able to avoid it by using that type of device.
Yeah, I would just say, and I agree with Andrew, revocable trusts don't really provide a tax benefit. Where they provide a benefit in terms of cost savings is they save probate costs because they make for a much smoother administration of your estate after you pass away. So the benefit is not so much a tax benefit, but there is a cost benefit to setting up a revocable trust in the potential savings for probate fees and costs like that.
Well, gosh, thank y'all so much for being here. I feel like we've learned a lot today, and I think we're going to have you back on the podcast to talk about more because I have some more questions for you.
Yeah, I'd love to come back.
Thanks, Lauren.
Thanks.
Thank you so much.
Thanks for tuning in, guys.